Paging Aitken Robertson to courtroom number 2. The jury is back with a verdict. Members of the jury, how do you find the accused? Guilty or not guilty?
Not guilty on all accounts, Your Honor.
Hi everyone. Today I have counsel Taryn Paul Dhaliwal with me on the Legally Speaking Aiken Robertson YouTube channel. We will be discussing the various outcomes in a criminal case. So when you are caught up in a legal ordeal, sometimes the primary goal is just to put an end to the nightmare. But how does that actually happen? There are multiple ways and pathways to a resolution, and each with its own implications. Which route to pursue depends on the individual's objective, shaped by the specifics of their case. So, factors like potential consequences, associated cost, the feasibility, all play a crucial role in determining the best course of action. So, common objectives by clients we found include avoiding jail time, steering clear of a criminal record, minimizing expenses, expediting the process, and ultimately establishing innocence. Taryn, in a criminal case, sometimes things can be resolved before it gets to a trial. Can you tell us a little bit more about that?
Absolutely. So, what I often advise my clients is that the first step in any criminal case is to review all of the evidence. The evidence is referred to as disclosure. So, once we receive the initial disclosure, I would go through it. I would go through it with my client, and we would determine number one, what's outstanding from disclosure. So, for example, the Crown attorneys will often provide a initial disclosure package, which is typically a PDF document outlining a synopsis of the allegations. Oftentimes, there's further disclosure, such as videos and audio statements that may or may not be disclosed at the same time as the initial disclosure. Once the disclosure is received and reviewed, the next step would be to schedule a Crown pretrial meeting, and that the initial discussion the defense lawyer has with the Crown attorney. At the Crown pretrial, you can discuss a potential resolution. You could discuss any triable issues, and you would try to essentially negotiate with the prosecutor at that time to get the best result for your client without going to trial.
What types of outcomes can a person look into getting during the Crown pretrial?
That's a good question. Ultimately, it depends on what the charges are. So, for example, in an impaired driving case, one of the ideal resolutions oftentimes is to get the criminal impaired driving charge dropped and reduced to something non-criminal like careless driving, which is under the Highway Traffic Act. So that's one example in a DUI case. An example in a domestic assault case would be to try to negotiate to get the criminal charge dropped by way of a peace bond. A peace bond is when you do not admit to any civil or criminal liability, but essentially you agree that there is some sort of fear or basis upon which the individual is entering into the peace bond.
And what happens if someone is facing multiple charges? Can that have an impact during the discussions with the Crown?
It could, one of the negotiation tactics could be, for example, to have, instead of your client being convicted on 7 or 8 counts of assault, if you can negotiate with the prosecutor to have a plea to 1 count and to withdraw the other counts, that's another form of negotiation strategy.
If a plea deal has been reached with the Crown, what type of outcomes can a person expect?
So it really depends. For example, if there's an individual who's charged with impaired driving and that has a previous impaired driving conviction, the Crown attorney will likely seek jail time upon a conviction to a second offense. The mandatory minimum is actually 30 days jail for a second impaired driving conviction. So in a case like that, ultimately it's the client's call what their ultimate goal is. Oftentimes clients who have a conviction will do everything they can to avoid jail time. So if you can negotiate with the prosecutor to avoid jail time, that would be considered a win in those circumstances. In other circumstances, if the evidence is overwhelming or if the client simply wants to accept responsibility and walk away without a criminal record, a conditional discharge is one of the other outcomes that you can try to negotiate. Conditional discharge is when you would plead guilty, but a conviction would not be registered on a criminal record check. If the individual did get a background or criminal record check done, it would appear on that record as a conditional discharge. A discharge would get removed automatically after 3 years. There's also a absolute discharge, which you can try to negotiate. An absolute discharge is essentially the lowest sentence available in the Canadian criminal justice system. Another potential outcome is a peace bond, as I discussed previously. And so there's a multitude of ways that criminal matter could resolve, and certain wins are dependent on that individual's particular circumstances. Again, there could be an individual who is charged with multiple assault counts. If that individual is a permanent resident, to get a discharge would be advantageous to that client because they would essentially avoid a criminal conviction.
What happens if, while discussing this with the Crown, you guys cannot come to an agreement, or the plea deal that you got for the client is not acceptable? What happens next?
If there's no prospects of resolution, typically in a case like that, the matter would proceed to a trial. When you go to trial, that's essentially the last leg of the criminal matter. A trial is when the judge would determine ultimately whether or not your client is guilty. The onus is on the Crown Attorney to prove the case beyond a reasonable doubt. And ultimately, if the matter does proceed to trial, the ultimate goal would be to get the client acquitted and found not guilty.
Thank you. And then how does someone actually go about and decide which path to take? To accept the plea deal or to take it to trial?
You need to ultimately have a very thorough and comprehensive discussion with your lawyer and find out, if we do go to trial, what are the odds of success? What can I be looking at after a conviction? And what are the pros and cons of resolving it without a trial? So there's a number of things to consider before you go that route. Also, trial is oftentimes a lengthy and expensive experience as well. And so clients often take into account the legal fees associated with litigating a criminal case at the trial or appeal level.
Thank you so much for joining us today, Taryn, and to discuss the different winning outcomes of a criminal charge. How do clients get in touch with you?
The best way is probably to go on our website, fightthecharges.com.
There you have it, folks. Don't delay. Get in touch with us at Aitken Robertson today. Thank you for joining us at the Aitken Robertson YouTube channel. And don't forget to subscribe and hit that notification bell so you never miss another video. Until next time, stay informed, stay engaged. Take care. Thank you for tuning in to Legally Speaking, proudly brought to you by Aitken Robertson Criminal Defence. We represent clients facing criminal charges all over Ontario, providing you with legal support and dedicated advocacy. If you enjoyed this episode and want to see more content, please like and subscribe to our channel. For more information, visit our website. We also offer free books on various types of criminal charges, which you can request on our website or by using the QR codes on your screen now. For legal assistance, call us today or visit our website to request a meeting with one of our experienced lawyers or licensed paralegals. Thank you for watching, and we'll see you next time on Legally Speaking.